Hey everyone, Michael Strickland here. For those of you coming across this video by pure chance, I was the news videographer who was attacked by a gang of thugs when I was out filming a protest in the summer of 2016 in Portland, Oregon. Except I was the one who was arrested and charged with multiple felonies for not wanting to be beaten and robbed. Well, the gang of thugs who premeditated and carried out the physical attack on me are considered to be the innocent victims. So as I continue to fight my case, I just wanted to update everybody on the status of everything. Today's date is May 9th, 2020, and some of you who have been paying attention to the case may be aware that on April 1st, April Fool's Day, conveniently enough, the appeals court finally issued their opinion on my case, and they affirmed the lower court's ruling. So as of now, that means that the conviction stands. I'll be getting more on that because this is hardly the end of it all. So what the appeals court does whenever they issue one of these opinions on a case that comes up, they oftentimes do these little written briefs about it and how they came to their conclusion. Sometimes they affirm without opinion. In this case, they actually did write a thing here on it. So written by Judge Rex Armstrong. Defendant appeals a judgment of conviction after a bench trial for 10 counts of menacing and unlawful use of a weapon. The charges arose out of an incident at a demonstration in downtown Portland at which defendant brandished a handgun at a crowd when he felt threatened. So they're admitting right there that I felt threatened and that's why I drew the handgun. It was not to intentionally commit a crime. It was, of course, purely in self-defense against what I consider to be unlawful force being used against me. Defendant raises 6 assignments of error. We write to address only defendant's contention that the trial court erred in granting the state's motion to exclude irrelevant evidence of a prior incident in which defendant was injured, blah, 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 blah. So they're only writing to address one of the assignments of error that we raised in the appeal. I'll get into that a little bit later here. Of course, this particular incident they're talking about is when my arm was broken the year prior by a violent, phony documentarian guy by the name of Sky Fitzgerald, who we caught lying to people for his gun documentary that he was making. And when we called him out on his lies, when he was caught, his reaction was to steal 2 video cameras from me and body slam me onto the pavement, shattering my arm, leaving me with multiple fractures all through my arm, requiring multiple surgeries, months of being whacked out on oxycodones, months of physical therapy. I'm left partially disabled. And now these judges are saying that's irrelevant. Just a year later, when I'm facing an even more precarious situation where I now have 10 people coming after me, many of whom are much larger than me. So these judges basically think that they have the ability to read my mind. They're saying that they have the ability to tell me what I was or was not thinking during this very chaotic, very dynamic, very stressful situation that's changing second by second, where I'm being chased by a gang of thugs that had just been pushing and shoving me around inside of a crowd simply because I'm standing there holding a video camera. These judges are trying to tell me that this prior incident from a year beforehand did not weigh into my mindset. Of course it weighs into my mindset, you know, because I had literally been beaten and robbed just a year prior. And all these people coming after me here in the 2016 incident, you know, most of them have masks over their faces. There's no police anywhere. I know that if these guys were to beat and rob me, they're never going to be identified. They're never going to be brought to justice. So, of course, this prior incident weighs into my mindset. So they go on to say here, the facts are undisputed. Defendant attended a public demonstration in Portland with a video camera and film speakers and demonstrators. He openly carried a semi-automatic handgun in a hip holster. No, actually, that is not at all the fact of the case here. I was concealed carrying, of course. I'm not going to go to something like that in open carry. It's just stupid. I don't want to attract attention to myself. You know, I always like to have a fly on the wall kind of mindset about things. Let's see here. The state presented evidence that defendant was known to several of the demonstrators, and they had decided to confront him and tell him to leave the demonstration. So again, they're admitting that this gang of thugs premeditated this altercation with me. 4 demonstrators wearing bandanas over their faces approached defendant aggressively, calling him a racist and telling him in strong language to get away. First of all, it was not 4. It was 7 of them, as seen on video. So either these judges are not even looking back over the evidence, or they are intentionally lying in their written summary here, because it shows on video 7 of them gathering up beforehand, and this is in one of my videos you can see on my channel here. 7 of them gathering up, huddling up, formulating their plan to come in and attack me. Now, this is important because the crime of riot is committed when 5 or more people engage in alarming and tumultuous behavior to alarm the public, or something to that effect. And riot is a Class C felony. So by them saying there were only 4, they're trying to minimize the level of threat that I felt from the gang. First of all, 4 versus 7. And secondly, they're trying to protect the gang of thugs by claiming that the gang of thugs were not engaging in unlawful behavior towards me, because if they were to admit that there were all 7 of them, at least in the beginning, the numbers changed throughout the thing as people are running in and out of the scene, but then they basically have to admit that, yes, these guys engaged in a felony against me. But there's more, too. I mean, it's not just strong language and aggressively. It was a 400-pound multi-time federal felon, Benjamin Carenza, who started pushing and shoving me, screaming, "You need to get the fuck out of here," which I consider to be a direct threat and unlawful force being used against me. So as defendant backed away, the demonstrators continued to move towards him. They're admitting these guys continued to come after me after starting this fight. One of the demonstrators noticed defendant's handgun and pushed defendant away. Defendant responded that he was not racist and told the person, "Take your hands off me." So that's not exactly what had happened, because the pushing and shoving happened before the gun played any part, before I had flipped my jacket open. Again, because I was carrying concealed, legally, by the way. I mean, if I haven't made that clear, I was a 5-year legal CHL holder, been through several different firearms trainings over the years. So now this isn't true. This is another undisputed fact that not only is erroneous, but was heavily disputed throughout the trial and all the other hearings and in the briefs here to the appeals court. So it says here, defendant continued to move backwards, holding his camera in one hand and twice placing his other hand on the handgun, which was holstered at his hip, causing people in the crowd to cry out. As I am oft to say, if you don't want somebody to pull a gun on you, then don't gang up and start fights with people in the street. That's a good way to end up getting shot. So it says a person carrying a large news camera stepped between defendant and the 4 bandanaed protesters. No, there were a lot of people here, more than 4. Creating some distance between them and as the defendant continued to back away. In the conduct that gave rise to the instant charges, defendant took the handgun from its holster, held it with 2 hands, and scanned the crowd from left and right. That's somewhat sort of true. First of all, there were more than 4 of them, but what they're missing here is Malcolm Chaddock, another person whom I've seen at protests committing crimes and causing trouble, was circling around my back, providing a distraction for me to the right here, while Ben Carenza is then running up on my blind side. And when I noticed Carenza out of the corner of my eye coming up on me, the guy who had started the fight, that was the decisive moment in which I drew. They leave that part out of their written thing here. So it seems as though that the appeals court had already made up their mind before even looking at the case, before even reading the written briefs, before even having the oral arguments, and they've had to invent erroneous quote-unquote facts that fit the narrative that they already created. Now, this goes back, and then this continues on with a whole bunch of mumbo-jumbo here, legal stuff, blah, 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 blah. Basically, them excusing the gang of thugs for attacking me. So where we went from there is you are allowed to petition for reconsideration based on a challenge of the, again, quote-unquote facts. I've seen this done in other appeals cases. Where they review the case again after being corrected on some erroneous facts. And if I'm giving them the benefit of the doubt, I'll say that there's a lot of conflicting information in some of these written things. Some of it are prosecutors and state attorneys intentionally lying to the appeals court about what did or did not happen. Again, I have that in some other videos here on my channel you can go look at. So even if giving them the benefit of the doubt, okay, so they got some of these facts wrong. So we petitioned for them to reconsider the case, and we pointed out all these factual things that they have incorrect here. So this past Monday, May 4th, I believe, they issued their opinion that they are not going to reconsider the case. So where do we go from here? We go to the state Supreme Court at this level. But again, this scary thing is they are allowed to reach their opinion, reach their conclusion here based off of several erroneous things from the case. And if they can do it to me, they can do it to anybody else here. And so they only wrote, again, to address one of the assignments of error that we raised, which means they're saying the other 5 are perfectly acceptable. They're saying it's perfectly okay for district attorneys to go before media and make false claims about a defendant's political beliefs or racial beliefs or whatever. Again, I have a video about Kate Molina lying in front of the judge with all the cameras rolling, claiming that I have ties to white supremacist organizations, and I'm going around flashing my gun towards this one dude that I hardly even know, that from a week prior who had gotten in my face screaming and yelling at me. All these things completely untrue. The appeals court is saying that district attorneys are allowed to do that, and the effect of that tainting a jury pool is perfectly acceptable. They're saying that my statements made to the detective about how I felt threatened, about how they'd encircled me from behind, pushed and shoved me, how I was trying to get away, how I believed what they were doing was unlawful towards me, and that's why I drew. My statements to the detective were ruled to be inadmissible. And the appeals court is saying that's perfectly okay. And the fact that 8 of the 10 alleged victims never came forward, were never identified, and that I was denied my right to face my accusers because they never accused me, appeals court says that's perfectly acceptable. There are multiple definitions of unlawful use of a weapon here in Oregon, and we had motioned during the trial, or during the pretrial hearing, for the state to clarify which part of the law they're charging me with. They didn't want to do it, and the judge said, yeah, it's fine, they don't have to do it. The appeals court is saying prosecutors don't have to even explain what part of the law they're going to charge you with. They can leave you with an impossible defense because you don't even know what you're defending yourself against. The appeals court is saying that prosecutors can put forth ambush witnesses after both sides have arrested witnesses who weren't even on any witness lists were exchanged beforehand, and then they're allowed to testify with a legal conclusion as to someone's case. Appeals court says that's perfectly fine. Perfectly acceptable. In contrary with Oregon law, Oregon Bench Trial Handbook, and of course Brady and all of these other things, appeals court says perfectly acceptable. The appeals court is basically saying all of the First Amendment restrictions that have been placed on me, banned from filming protests, banned from talking to the media, all these different things that have been placed on me throughout this whole thing, perfectly acceptable. They're essentially saying the First Amendment does not exist. They're saying that one does not have a right to do that, because if it's a right, then it can't be taken away like that. The appeals court says, oh, that's perfectly acceptable. So where do we go from here? We now take it to the state Supreme Court, where we're allowed to bring up all of the things that we had brought up in the initial brief and everything now that's happened through the appeals court. And I don't know if we're allowed to bring up even more things during that. That'd be great if we could, because we could assign even more errors done during the trial to this. We also get to bring up other rulings that have been put out by the higher courts since everything had happened to me. Because these are things that weren't known when we initially filed the appeal and during the trial itself here. One such case is State versus Damon James Nowdane. Now, this guy here was convicted of murder after he and a few other people decided they were going to rob their drug dealer of drugs and money, and he ended up killing the guy in the process here, and he was convicted of murder. And the case was overturned in part due to, this is out of the higher court's ruling here in Oregon. Defendant, however, asserted that he had discharged his firearm accidentally and that he did not intend to kill the victim. Now, applying that same thing to my case, I did not intend to unlawfully use a weapon. I did not intend to menace people. I did not intend to engage in disorderly conduct. I intended to defend myself against what I considered to be unlawful force and imminent further unlawful force. So all of these things we can use as we continue to appeal the case higher. So that's on the one prong, is now we go before the state Supreme Court. The other side of it is I'm done with the appeals court now. I don't have to see these guys again. I don't have to deal with these guys again. Now, some of you who have been paying attention to the case may be aware that I do have a dead man switch. I have had nothing but nearly 4 years of time to investigate all these characters who have been involved in this whole case. And I've sort of put all that information into various different electronic vaults of sorts all throughout the internet here. Should something unfortunate happen to me, all of those things start to go public if I do not do certain things to prevent it from doing such. Now, I've had to do that as a defensive maneuver for myself in case they were to try some other shady business along the way, and it's just what I've had to do. But now that I'm done with these appeals court judges, I'm going to reveal just a wee bit of what I have in the Dead Man Switch vault. And that is my investigation into Judge Douglas Tookey. He is one of the judges on the panel here who went over my case. Now, this particular judge, and I'll be putting out some videos very shortly on this, but this particular judge has a tendency, a penchant, you could say a fetish almost, for going easy on rapists and overturning rape case after rape case after rape case based on minor little technicalities. So that's going to be coming up here on Laughing at Liberals. If anybody else wants to mess with me, I'll be more than happy to air your dirty laundry if you want me to, but I'd rather not do that. I'd rather just be left alone. Remember, I didn't start any of this. Everything I've done has been a reaction to what other people are doing to me. I wouldn't know or care who any of these people are had they not gone out of their way to make trouble with me. Those of you who also know me know that I hate begging for money. It's not what I like to do here. But it costs money now to bring this before the state Supreme Court. Robert Barnes is now my attorney. Some of you may have seen him on various different TV shows and podcasts and whatnot. He's an attorney to the stars of sorts out of L.A., and he's been my attorney throughout the appeal. He was not the attorney on the trial, but I think he's been doing a really good job. I'm pretty happy with his work so far, and I'm fortunate enough that he's passionate about my case. But it costs money to bring this thing up to the next level and continue fighting, not just for my rights, but for everybody's rights. Like I say, if they can do it to me, they can do it to anybody. If they're saying it is not unlawful for a gang of thugs to attack people on the streets to me, then that legalizes mob violence against anyone on the streets. So that's when, again, this case kind of turns from being about me to being also about my concerns for everybody else. So that's just one of the many reasons why I continue to fight. I do have a legal fund set up on PayPal. stricklandlegalfund@gmail.com is the PayPal thing. I'll put a link to it in the description and maybe in the comments there. If anybody wants to chip in, even just a few bucks here and there helps out. We're in the middle of the virus thing right now, so the economy is all wacky. Of course, being banned from working throughout most of this has dramatically affected my income and all the fines that I've had to pay, all the other legal fees I've had to pay. So again, I hate begging for money, but it's what I need to do to continue to fight this thing. So, every little bit helps. Again, on PayPal, stricklandlegalfund@gmail.com. I might try to, set up like Google Wallet and maybe a few other methods as well. But again, if anybody wants to help, I appreciate your help. I don't know what else to say. I'm thankful for everybody that's helped out so far, not just with the money. That helps a lot. But I'm also thankful, for people who maybe don't have a whole lot of money, who have been able to share my stories around. Like I said, feel free to go through some of my other videos here on my channel. I used to be a news videographer. I used to film political events in the area until this happened. So if you don't have any money, please share some of the videos around about what's happening. Help spread the word about what had happened to me. Again, I'm thankful for everybody's support, and as I've said several times before, I have no intention of giving up this fight until it gets overturned at whatever level it has to go to in order for me to be vindicated, for me to have my life back, for me to have my rights back, and for this wrong to be righted. Thank you.